So kind of more importantly, and the things that, we're getting lots of questions about on a daily basis is the effect of COVID on immigration processing within the US. So if you're here, what are some of the impacts we're seeing in immigration processing? So I'm going to talk about a couple different visa types, some of our main, more popular non-immigrant temporary work visas. I'm going to start with H1B because that's one of the most popular non-immigrant temporary work visas. So for H1B, processing times have remained mostly normal, and premium process has not been suspended. So it's still been possible to get a 15-day decision when you file a case, or if you upgrade it later. So the main focus for those that hold H1B is maintenance of status issues. And that's because obviously, as Praveen was talking about, and with the land travel, it's not ideal to leave the US for immigration purposes, let alone health reasons. Travel isn't really recommended. And so you wouldn't want to be in a position that you're forced to travel out. And one of the ways you can be forced to travel outside the US if you're here on a non-immigrant visa is if there's a maintenance of status issue, or you're found to have had some kind of lapse or a violation that would require you to leave and come back. And obviously we want to really avoid that, particularly now with COVID. So one of the things that I'm seeing a lot, and I know is something that people have questions about, due to the increase in remote work, there's been a lot of questions about when do you need to file an H1B amendment, because maybe initially during the pandemic, you filed an amendment for a project and so you included your home location because you're working from home. So then over the last year, this is, mostly pertinent to the IT industry, but so maybe you've changed projects, but you didn't file an amendment because your home location is already in your LCA. USCIS does consider new projects or in-client changes to be material. So just because your home location is included in your LCA does not mean that you don't need to file an H1B amendment if your project changes or if the in-client changes. And that makes sense, right? Because if it's a new project or you're working for a new in-client, obviously it's not going to be identical to the conditions of your approved H1B. It's unlikely the job duties or everything would be completely the same. So you're going to want to make sure that you're carefully filing amendments for any changes. Because again, like I said, if you were found to have any sort of lapse or you later file an extension, you can get an RFE. They can question the fact that the new project was not included in the previous filing. And then if that happens, you could get an approval without a 94. And then at that point, you're going to have to step out. So we do want to be really conservative during COVID about maintaining status for all visa types, particularly with H1B, with the remote work, because we are seeing that, create questions or people being a little bit more relaxed about amendments because they're already working from home, but you'll want to be careful about that. And if you ever have any questions about whether something is a material change or requires an H1B amendment, you always want to consult with an immigration attorney. So if you happen, amendments aside, you're filing to change your status or you're filing to extend your status, what happens if it's denied? Because typically in that case, you would need to step out. But we do advise, not traveling at this time unless it's an emergency. So two different scenarios in the H1B context. For change of status, mostly that's applicable to those who have filed in this year's fiscal year cap. So that's for changes of status that will be happening in October. So this is mostly pertinent to people who currently are on F1 status, since that's typically the visa status that people hold when they file their first H1B. So if you have an H1B approved with an October start date, but it doesn't come with a 94 because they find some prior issue with your F1 maintenance of status or any other status like your H4 status, any other non-immigrant status, where they end up approving your H1B without an I-94. For those individuals, you'll be able to remain in the US and continue to maintain your current status. You'll want to consult with an immigration attorney, because if you get a denial notice on your change of status that alerts you to a violation of your status, it may be a different scenario, because once you know you're violating your status, if you remain, you're looking at unlawful presence. But in general, if you were to get an approval without an I-94, you'd be able to remain in your current status. So if you're on F1, you can continue going to school, working on CPT or OPT. And then when travel restrictions have been lifted or consulates are open, then you could step out to attend stamping at that time, when it was going to be possible. For non-quota cases, you'll want to contact an attorney before traveling out to make sure that there's no other options. So you could explore filing a motion. So in the H1B context, this would be, you could file a motion to reopen and reconsider. which doesn't grant you status. So you'll need to talk to an attorney about what the likelihood is of getting a decision quickly on that. You could file motions for sua sponte relief, which is asking them to open it on their own due to a government error, if that's the case. There's also the possibility of motions nunc pro tunc, which is asking for relief based on past eligibility. So refiling and asking them to excuse the timeliness of the filing. You know, if you have a denial and you're applying again, but your I-94 is already expired. And those are good options to avoid traveling out. That would also be applicable for H1B transfers. Anything that leaves you without an I-94, so you'd have to travel out. Before you do that, we recommend talking to an attorney to see if there's alternate kinds of relief or other options that would allow you to remain in the US. Just because if you step out, if you're not exempted and there's still geographic travel restrictions, you may not be able to come back in for some time.
And the general approach, I think, Julia, what I understand from what you're saying is to actually explore all the options to stay in the US by filing either motion to reopen or even refiling as such with a non-protect request to consider a timely filing, even though you're filing after the I-94 has expired, to explore all the options to just make sure that you can continue staying in the US and get the benefit. Because I have also noticed that USCIS is actually considerate on these options based on the pandemic situations in different countries, right?
Right. We are definitely seeing USCIS be, you know, more lenient on these issues. And a lot of times when you have, you know, cover letters that are explaining why someone can't travel out, and because of we're seeing this a lot for like visitor visa extensions, why people can't step out and why it's important to get relief in the US. USCIS obviously understands that. So we are seeing them give a little bit more grace than maybe we're used to from USCIS. So it's a good idea to explore those options just because the likelihood of a favorable outcome is higher than maybe in the past. So now I'm going to talk a little bit about H4 processing related concerns. I think there's been a lot more concerns for H4 and H4AD over the last year than H1B, which hasn't been as affected in terms of processing in the US. There have been pretty significant delays for H4 processing, which was due to the biometrics requirement because they weren't doing biometric requirements and taking fingerprints and stuff during COVID. But beginning on May 17th, USCIS has suspended the biometrics requirement for certain 539 applications. So if you filed an H4 case and it's pending and you have not received a biometrics notice, you were not going to get one. They'll continue processing it without it. If you filed an H4 and you received a biometrics notice, you still need to attend that appointment. But anything filed, you know, here on out, there won't be a biometrics requirement. So we do expect that that's going to help a little bit with the processing times. But I think that the main concern people have had has definitely been H4 EADs, because if your H4 is pending, you can stay here. It's not a huge concern. If your H4 EAD is pending and your current EAD has expired, you're not able to work. And so this has been a source of major frustrations for many of our clients. You can see it on discussion boards. You can see different blogs, people signing petitions. This has been a major issue over the last year. So a lot of these delays were due to the biometrics for the H4s, which obviously has now been, there's been relief on that. There was also a federal lawsuit filed in March of this year that seeks to take care of three things. And the first thing was the biometrics requirement, which has now been resolved. So that's no longer an issue. But the other thing that this lawsuit is trying to accomplish is to make DHS provide automatic work authorization when your EAD renewal is pending. So if you file your H4 EAD extension on time, you'd be able to continue to work until you get your renewal, which would obviously be a huge relief for many. And then to also allow individuals to file their extensions more than 100 days before, because currently you have to wait until you're at that 180-day mark. But we know that USCIS is taking, you know, up to a year in a lot of cases to approve these. So you're having people have these, you know, major gaps in work authorization. So if successful, you know, we do think that lawsuit will bring a lot of relief. In the meantime, and I get asked probably on a daily basis what you can do, how you can expedite your H4 EAD. They've been processing for a long time. You can call USCIS. You can ask for an expedited request. You can call the number. The website also says that you can ask Emma, and then you just have to contact USCIS in some way. And then you'll have to prove that you qualify for an expedited request. So severe financial loss is one of the, and humanitarian reasons are one of the ways that you can, you know, have that granted. But we are not seeing USCIS grant the expedited request. And that's because no one is in a unique situation. Everyone's has been delayed, but it's definitely something that people can try. People are also writing letters to congressmen and just trying to get relief in this area. But I think that the thing that's most likely to get relief is if this lawsuit is successful, because allowing people to have work authorization while it's pending would obviously alleviate this entire problem. So
what I'm also curious is, Julia, to see the getting away with the biometrics requirement might allow USCIS to now process H4 and H1 together when especially they file it in premium processing. That's been separated, and there's no benefit of premium processing on a H1B, which is passing on to the H4 as it stands today. But I'm curious to see if that actually is taken back, and maybe the H4 also gets approved immediately when they file the H1 with the premium. And if it is all together, that also has an impact on the H4 EAD. So
right,
that's that we have to wait and see probably.
Yeah, that's a good point. I do always remind clients that H4s aren't by themselves eligible for premium, and that when we send them all together, it doesn't necessarily mean they'll be processed in premium. But we have seen over the years that when you file them all together, typically the H4s do get approved faster. And a lot of these delays were because the biometrics, where they started separating them and they're in different processing centers. And then it's been a really lengthy process. So I think that's a good point. I think that removing biometrics will be helpful. One, and just now one of the requirements is gone, and two, we can file them all together. And the ones that are premium means that H1B is approved within 15 days. They immediately have the approval they need to approve the H4. So hopefully that'll also help.
Right.
So now I'm going to talk a little bit about TN visas. So these are your, your professionals from Mexico and from Canada that are Canadian citizens and Mexican citizens under NAFTA. We want to remind people who are holding TN status that the best thing to do is to file their renewals and extensions with an I-129 petition. A lot of times people pre-pandemic would just travel to Canada or Mexico and come back the next day and go ahead and do the renewal at the border. We don't obviously recommend that, because while the borders are they're closed, but they're allowing for essential travel for workers. There are different requirements. So I know in Canada, if you cross over the border, they want you to quarantine for 14 days. So it's not going to be some quick thing anymore to go and get your TN renewed and come back. So that's something to think about. For Mexican citizens, you do have to have a valid TN visa to enter. That's not the same for Canadian citizens. But Mexico has very limited visa appointments right now, but they did expand their interview waiver requirement. So now the in-person interview will be waived if you have a valid TN stamp, which expired less than 48 months ago. So that should help with getting visa appointments for Mexican citizens. For Canadians, they are included in essential travel, so you should be able to go back and forth. But again, that quarantine requirement is something to think about. The closures, they don't apply to air travel, so you should be able to apply for TN status at the pre-flight inspection offices at the airports, but you will have to have a negative COVID test in a Canadian airport before you board. But the best thing to do, obviously, is to file it. If you're in the US, stay in the US, file your I-129. It's eligible for premium, but even without premium, you can remain in the US and work on the extension. As long as you file it, you can work 240 days beyond the I-94 expiration date. So that's the best thing to do for TN professionals. For E2, so our investor treaty visas, same thing. You should file extensions in the US using an I-129 because E2 visa processing abroad has been very delayed due to COVID. Processing times have been really high getting your visas overseas, which can take up to like 9 to 12 months. The other thing to think about is that now we have geographic travel suspensions in a lot of places. So that will be unavailable unless you can get a national interest exception. So if you're in the US, stay in the US, file your renewal here. And again, same thing with the 240 days with the I-94 expiration date. So that's the best thing to do for E2. And E2 is eligible for premium processing. So should you need a quick decision, it's available. I think most people, when they need premium processing, it's usually because they need an approval before they travel, which doesn't really apply to anyone anymore. But should you need that approval quickly, it's still eligible for premium processing, which helps. So now we're going to talk about L1 visas for a little bit. So travel is not recommended, particularly for L1 holders. And Praveen touched on this earlier. because of the travel suspensions, most consulates are not issuing non-immigrant visas unless you can get an NIE. And the reason that then an NIE is going to be tough for L1 is because executive and managerial type job duties are not considered vital support. Typically, you know, supervising or overseeing employees is not critical to the business. So it's unlikely, it's not impossible, but it's unlikely that these are going to be granted for NIEs. So if you're in the US on L1, we do recommend that you file your extension here, just like with the TN and the E visas. I think that it'll be tough for L1A, particularly I think L1B, so your employees with specialized knowledge might be a little bit different. But the reason that we don't think that L1 is going to have an easy time getting an NIE is because initially the geographic travel suspensions allowed a specific exception for these individuals, and they've been removed, which is a signal that this is not something that the US is currently considering as something essential to be included or exempted. So we can't expect that that might be a little bit tougher to show that vital support element for L1. So just as a wrap up of some of the employment-based immigration considerations for those currently in the US, as I said, maintenance of status is absolutely critical. And travel outside of the US should be avoided except for emergencies. When you file a change of status or extension of stay or really any other petition, you're going to want to make sure you have strong documentation. And that's always true, but it's more true now than ever because you want to avoid a denial, you want to avoid a lapse in status. So it's really important that you prepare those petitions in advance. If you're working with an attorney, you know, bringing the case well in advance so there's time to make sure you have the documentation that you need and that you can get that straight approval and you don't have to worry. If you have questions, you should always reach out to an immigration attorney. I'm probably this way all the time. I'm a conservative immigration attorney. Don't take risk. I'm always going to err on the side of an amendment versus not because I think you should be really careful. But now more than ever, I think everyone needs to be conservative with immigration petitions because traveling out is just too risky. And then I just wanted to obviously emphasize that we're here to help. So you can reach out to us for any of your questions about employment-based immigration or family-based immigration, which Leah is going to talk about next. So I will turn it